Well, hello everybody and welcome. I'm Professor Melissa Caston, the Director of the Caston Centre for Human Rights Law here at Monash University. I am very pleased that we can come here together today to address this important issue of the upcoming referendum that's going to be held on the 14th of October this year. So thank you for joining Talking About the Voice, a conversation without the noise, presented by the Caston Centre for Human Rights Law in conjunction with the Australian Association of Constitutional Law, Griffith Law, and the University of Queensland. And thank you to all of these organisations for supporting this webinar. Today's webinar will be recorded and made available for viewing shortly after the event. And we may also be broadcast on ABC Radio National at some point. So I am joined by a terrific panel of experts today, and in a moment I will introduce them to you. But first I'd like to start today by acknowledging the Bunurong and Bunurong and Wurundjeri Woiwurrung peoples of the Eastern Kulin Nations as the traditional owners and custodians of the lands where I'm talking to you from today. And I invite you now to consider the country where you are joining us from and acknowledge the people deeply connected to that place. We pay our respect to Elders past and present, and I'd also like to acknowledge and welcome all First Nations people who are joining us here today. I'd like to observe that in my role as an educator and a scholar of the law, I feel I have a particular role to play in addressing the dispossession caused and the continuing impact of Captain Cook's Law as it applies across Australia. And I know that many of my colleagues also feel the same imperative. It's over 30 years since the High Court handed down the judgment in the Mabo case, and it's over 25 years since the Bring Them Home report by Sir Ronald Wilson and Professor Mick Dodson was published. And these are just two key steps in the national journey of many, many steps from the imposition of Captain Cook's Law to the restoration of proper legal relations between First Nations and the settler state of Australia. Now we are at the next step in that journey, the referendum and the implementation of a voice to Parliament at the federal level, a proposal that Noel Pearson described as simple but profound. So with that in mind, I'd like to turn to introduce our panellists today. So first I will start with Dr. Dani Larkin from the University of Queensland. Dani is a Bundjalung and Kangara Kane woman from Grafton, New South Wales, a public lawyer, a senior lecturer in the University of Queensland. And Dani's research interests include issues that surround constitutional recognition and electoral law and policy reform. Good morning, Dani.
Thanks, Mel. Good morning.
And next is Associate Professor Kate Galloway, who is a lawyer and academic at Griffith Law School. She researches and teaches in property law and is particularly interested in issues of land tenure and the law's effect on land rights, principally for First Nations people in Australia. She investigates the intersection of property as private law and sovereignty as the public law manifestation of rights over land. Drawing on her research and her experience in community legal education, Kate is currently leading a community engagement project in learning about the rationale for the Voice proposal, enabling voters to make an informed choice in the referendum. Good morning, Kate.
Hi, Melissa.
Professor Luke Beck at Monash University. Professor Luke Beck is a Professor of Constitutional Law and also the Associate Dean of Education in our faculty. He's a leading scholar in the field of separation of religion and government and religious freedom under the Australian Constitution. He's also published on various other aspects of constitutional and public law, including misinformation in political advertising, referendum law, and freedom of speech issues. Hi, Luke. I think we got you on.
Thanks so much for having me, Melissa.
And finally, Professor AJ Brown, AM, a Professor of Public Law, Public Policy and Law in the School of Government and International Relations at Griffith University, and co-leader of the Centre for Governance and Public Policy's Integrity, Leadership and Trust Public Trust program. AJ is a 30-year veteran of developments in Australia's public integrity systems, and he's previously worked or consulted at all levels and across all branches of government in Australia. He's a member of the Australian and global boards of Transparency International, the World Anti-Corruption Organisation, where he has led the development of the current strategy, Holding Power to Account, 2021 to 2030. Sounds like a strategy document. Welcome, AJ.
Thanks, Melissa. Good to be with you.
So I'd like to start our discussion, and we're aiming to have the panel address some key questions that I'm going to put to them. And then if we have time, we'll be able to turn to your questions. But we do have to have a hard stop at 1:15. So I'm going to be very conscious of the time and be a bit of a taskmaster on the time frame. I would like to invite the audience members to engage in the Q&A function through the window, which you'll find located in the side of or below your video, depending on your device. And at the end of the session, if we do have enough time, we'll be able to choose some questions out of the Q&A inbox, and I'll put them to the speakers. But be sure to post your question as anonymous if you don't want me to read out your name. Given that we're recording and have the possible broadcast. So with all of those instructions in mind, I'm now going to turn to the actual start of our program. And I'm going to start with Dr. Kate Galloway. Kate, can you provide us with a brief overview of what the Voice to Parliament is and what is its significance in the context of Australian law and politics?
Thanks so much, Melissa. So the referendum is proposing to establish a permanent committee, if you like, called an Aboriginal and Torres Strait Islander Voice. The Voice will be comprised of Aboriginal and Torres Strait Islander people selected by Aboriginal and Torres Strait Islander people. And its purpose is to make representations to government and the Parliament on matters affecting First Nations people. So that means that the Voice can share with lawmakers the knowledge and experience that Aboriginal and Torres Strait Islander people have themselves. And the goal is that law and policy concerning Indigenous people will improve because of this input. So currently, alone of all Australian communities, Parliament makes special laws about Aboriginal and Torres Strait Islander people. But experience shows us that these laws are made without reference to the views and experiences of First Nations people themselves. And importantly, evidence shows that including people in decisions made about their lives will give better outcomes. So, although the activity of the Voice, making representations, is modest, and I think you referred earlier to Noel Pearson's comments, including it in the Constitution would be a significant moment for Australian law and politics for two reasons. First, it will be the first positive affirmation in Australia's founding document of the pathway, if you like, for the Australian state to engage with First Nations peoples as communities. It changes the relationship from one of dominance by the state over people's lives to allow the space for First Nations people to have standing on their own terms. And secondly, although modest in its operations, having this institution within our governance structures paves the way for cultural change in how government does business. It's a means of holding Parliament and government to account for the decisions that they make about Indigenous people.
Thanks so much for that, Kate. That's very clear. I'm going to now ask the next question of Professor AJ Brown, and I want to turn to the referendum that we're going to vote on in some 5 weeks' time. I wanted to ask you, AJ, why do we have to hold a referendum? And what are some of the challenges that are before us with achieving a successful referendum outcome?
Yeah, sure. Thanks, Melissa. Well, Well, we have to have a referendum, which is a vote of Australians, voting citizens, because it's the only way we can change our Commonwealth Constitution, which is the foundational document setting out the rules of government of Australia as a nation. In our case, as a colonial or post-colonial, we sometimes like to think, nation. And here's a copy of the Constitution. And under Section 128 of the Constitution, that's the only way that the Constitution can be changed. And that really reflects the fact that that was the way the Constitution came into being. It was by popular votes of the people of each of, well, the mostly male, white Australians who had voting rights in the late 1890s, that the then voting populace of each of the colonies voted in favour of joining the Federation, and then that was the trigger. That was really the trigger that gave the Commonwealth Constitution its democratic force. And so that's reflected. That means of changing the Constitution is basically reflected in the Constitution itself. But what it means is that we need to have a majority of the whole of the voting population of Australia in favour of a change, but we also have to have a majority of the voting population in a majority of the states. And because we've got 6 states, it means a majority of people in 4 of the 6 states. The people in the territories, the voting population in the territories will get counted for the national majority requirement. But whether or not a territory votes in favour of recognition in and of itself won't make any difference. It's got to be 4 of the 6 states. So that's why we've got to have a referendum. And there are lots of challenges. I mean, it is actually a challenge. It requires a 2/3 majority of the states rather than actually a simple majority of the states, because we've got 6 states. So we have to have 4. If we had 5 states, we'd only need 3. So that actually always increases the hurdle for a constitutional change. But I guess the other challenges that always go with the referendum are, first and foremost, that is that people need to have some it would be easier if people already had some understanding of the Constitution and of the referendum process, and unfortunately a lot of Australians never get to know or think about the Constitution, what it means, what's safe to change and what isn't, because it's simply not good enough, not part of our education well enough. That's a challenge in and of itself, and always has been for referenda. So a lot of people are going into this referendum going, well, I don't even understand, I know they might know there's a Constitution, but I don't really understand the implications of changing it, blah, 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 blah. So that's automatically a challenge which people have to surmount when they're thinking about how to vote. And it's 24 years since we last had a referendum. So that's a quarter of a century. That's a big chunk of Australian history on a colonial time scale. It's a blink in the eye on a full-time scale of 65,000 years, but it's a blink. But it's a big chunk of time for people who are alive today, so that's a challenge. We know from past referenda, including ones that have succeeded, that it has to be a sound and a sensible proposal, and that's where we've really got 2 things going on here. One is that we know an overwhelming majority of people want to recognise Indigenous Australia's first people in our Constitution, because they're currently missing. And it's just not an accurate reflection of who we are or what we want our political system to be, to have that silence in our Constitution. And a vast majority of Australians want to recognise Indigenous people, Australia's first peoples, in the Constitution. That's a sound idea. It's a question of how, and it's got to be a sound way of doing it. And so, in my view, the Voice proposal is an extremely sound way of doing it, because it will make I think will make a substantive difference, improvement to the governance of our country. But that's what people are basically debating, is whether or not that is the case. Will it do that? Will it have unintended or unwanted consequences, etc.? That's really what the debate is about around the Voice. But people need to remember that the first and foremost thing that it's doing is just simply putting our First Nations into our Constitution. That's the crucial thing, and that's it's time to do that. So the debate is really about whether this is the way to do it or not. And then a couple of other issues. I mean, there needs to be popular ownership. Obviously, it's a popular vote. And I think the big challenge for the referendum this time is that people can own it, but people will find it more difficult to own it when it's not necessarily clear in their minds if Aboriginal and Torres Strait Islander people themselves own it. Now, we know that the vast majority of Aboriginal and Torres Strait Islander people do own it, have been consulted, generated the proposal, have endorsed it to a far greater extent than has ever occurred with any other proposal of this kind in Australian history. But obviously, there are some very prominent Indigenous voices out there that are contesting its value, and and that's valid for them to do that. But I think the challenge that it creates in the minds of non-Indigenous Australians is do we want to own this or not? Because we're not quite sure that in fact this is actually supported by an overwhelming majority of Indigenous Australians, and for good reason. And then fifthly and finally, there's the challenge that we know that referenda are almost guaranteed to succeed if they're supported right across the political spectrum, if there is bipartisanship or multipartisanship. We've had many referenda fail where that isn't the case, where opposition parties have seized the opportunity to seize a referendum as an opportunity to campaign against the government. And that's happened before in referenda. In 1988 was a classic example. And unfortunately, that's happening again. I'm not saying that's the only reason why some political parties might be opposing the proposal, but it's clearly a reason. And it automatically is a challenge, because it means that people have to think, oh, well, I have to think for myself. I can't just follow the queue. I either vote with my political tribe, but really it means that people have to think about it for themselves, and that's harder. You can't just follow that normal political queue, and so those are all big challenges for any referenda, and there's certainly big challenges for this referendum.
Thanks, AJ. And I think you've elevated a really important point, and that is this issue of the community education, and that people aren't familiar with what a referendum is and what goes into it. And we'll come back to looking a bit closer at the referendum amendment in a moment. But I just wanted to turn to Dani and ask you, Dani, from your point of view, what are the main arguments in favour of establishing a voice to Parliament, and how might it best be positioned to address historical injustices as well as looking into the future for Indigenous Australians?
Thanks, Mel. Yeah, look, before I answer, as a Bundjalung Kanarakan woman, I just want to pay my respects and acknowledge elders past and present on the lands that I'm dialing in from today. So I'm on Meanjin country of the Turrbal and Yuggera people. And I just want to acknowledge any Aboriginal and Torres Strait Islander people that are dialing in today for this webinar. So that's a great question. Firstly, it's about following through on political processes of this kind. Too often in Australia, us Indigenous people are advised by the Australian government to go through truth-telling type processes as a way of coming up with meaningful reform solutions to better our lives. The Royal Commission into Aboriginal Deaths in Custody is an example. The Bringing Them Home report from the National Inquiry into the Separation of Aboriginal and Torres Strait Islander Children from their families is an example. The Royal Commission into the Protection and Detention of Children in the Northern Territory that exposed the horrific abuse of children in Don Dale, Aboriginal children in Don Dale. That's another example. And the thing is, at the end of these processes, guess what? Nothing happens. At best, we get a report with hundreds of recommendations that provide sound, consulted on, evidence-based reform options to overcome those issues, but the government does nothing about it. We have this issue of a lack of political will in the Parliament to implement the recommendations. And that means to actually make change after the long process is completed for working out how to resolve the issue. Now, while we have increased Aboriginal representatives that are now in Parliament, and that's of course a good thing, there is a small issue with the kind of weight and pressure that we can place on those individuals in Parliament. Why is that? Well, it's because they are very limited in the kind of representation that they can provide to all things Indigenous at a national level. And there's a few reasons for this. Firstly, it's a cultural thing, which means a single Aboriginal person in Parliament cannot and really should not represent the collective Indigenous interests, because while we have shared experiences with dispossession, injustice and colonisation, we differ culturally and geographically to what we want and what we need in terms of law reform. Secondly, when we elect Indigenous representatives at elections into federal Parliament, they're typically members of a political party, and that means that they have to fall in line with their political party's policy interests and commitments. And not always will it be the case that those interests will be about a small, less than 3% Indigenous population. Statistically, it just won't be, because the party will always be dominated by non-Indigenous advocacy and interests. And thirdly, those Indigenous political representatives have been chosen by people in their electorate, which means that they are actually obliged to represent their constituencies' interests, inclusive of all wide-ranging matters, issues, and identities. They can't solely single out and focus on their Indigenous voters in their electorate. They have to represent their electorate's needs, inclusive of all voters. So we need an additional means of representation that speaks to both the executive and the Parliament on all things Indigenous, to take the load off our individual Indigenous political representatives in Parliament, and to also just to be pragmatic and catch up with other liberal democracies around the world who have a mechanism like The Voice in place. But there also remains too this thing called cultural respect. The regional dialogues which came together in the heart of Australia to produce the Uluru Statement called for a voice constitutionally enshrined first. And that's what's on the table. That's what's been asked for. So there's another argument for voting yes, which says the government needs to, after all this time and hard work, blood, sweat and tears, to actually actively listen to and implement what was called for at Uluru back in 2017. And this question of reform has always involved the Australian Constitution. It's always been about reforming the Constitution to recognise Aboriginal and Torres Strait Islander people's place in this country as traditional custodians of it. The only thing that's ever shifted since 1999 was the form recognition should take. And that's a good thing, because now the form has shifted from just a single line in the preamble of the Constitution that would do absolutely nothing, to a reform option that takes advantage to the nth degree of this opportunity, which is a voice, an Indigenous advisory body to make representations to the government. And finally, it's just so important that this body is constitutionally enshrined so that it always remains. There's been a long-standing history of Indigenous advisory bodies at a national level in this country that have been represented by non-Indigenous bureaucrats as members of the body with little to no exposure, understanding or experience with Indigenous people, communities or issues. Or some of the bodies or committees established in the past have had membership of people who have been cherry-picked from the government and are essentially tasked with falling in line and not rocking the boat, whether they're Indigenous or not. So it's been a huge power struggle of conservative oppression when it comes to previous Indigenous bodies being enabled to challenge the status quo so that actual positive change happens and makes its way back to communities. But the biggest issue, and I'll sum up on this, Melissa, the biggest issue has also been about how national Indigenous representative bodies have been constantly extinguished in Australia. And that's because they've been made just by ordinary Australian Commonwealth legislation. And the moment those bodies disagree with the government of the day, their establishing legislation is repealed and they are, as a result, extinguished. Or they've been set up as corporations like the National Congress, but they were defunded by government and forced into voluntary administration. So unlike the other bodies that no longer exist, if we enshrine the voice in the Australian Constitution, it can't be taken away, because you can't get rid of the Australian Constitution. And so no matter how the voice looks, functions, or how membership transforms over time, which will be in ordinary legislation after a successful referendum is had, It will always be. And its core role to make representations to the executive and the parliament will always be. And that's just it, which is a good thing. We get protection and ability to speak to the government and parliament on issues that impact Indigenous people, so that lawmaking on such issues actually makes change like it's intended to do. And that's how you address historical injustices faced by Aboriginal and Torres Strait Islander people. You give them a protected ability to have a say on law reform processes that positively impact them and their affairs.
Thanks, Dani. You've sort of captured the whole argument there. And I think you've actually addressed a couple of questions that have popped up in the Q&A, which you wouldn't have had a chance to look at yet, but I've been having a look at them. So there's a couple of questions that people have popped in there, but you've actually addressed them in your summary there. So I want to come back to this question of the referendum that we're actually addressing, and that sets in place this proposal that Dani's explained and its justification. So, Luke, can we talk about the words of the referendum itself and what the amendment is actually proposing? Because there's a lot of talk out there that people are finding quite confusing about the referendum does this or the referendum does that, and there's concern, as AJ said, it's been a long time since anyone's been involved in a referendum, and particularly probably 2/3 of the electorate hasn't voted in a referendum. So what is the referendum actually proposing?
Yeah, thanks, Melissa. So this is a really important question. There's all sorts of debates happening about things that aren't actually on the table. So we need to think about, what are we actually voting on? And we're voting on whether or not we should put in 90-something extra words into the Constitution. Now, the Constitution is not the detailed policy document about how government operates. The Constitution is basically the framework for how government in Australia operates. It distributes powers between the federal and state governments. It says there'll be a system of courts, but it doesn't say how many courts and which court will do what. It says there'll be government departments, but it doesn't say how many government departments there will be or which departments will do what. That gets decided over time. It says that we'll be a democracy and that we'll vote. But it doesn't say what that voting system will be. Parliament decides what that voting system will be. So it's a framework. It sets up the basic details, the basic structures, and then leaves it to Parliament and government to fill out the details over time and to change the details over time as society develops and as the world grows. And so what is being proposed here is that we add one new structure, which is called the Voice, that will provide advice to Parliament. It's an advisory body. All of the details are left to Parliament. And the words, as I said, there's 90-something words that we're talking about. And the proposed text essentially has 4 key parts. The first part declares that the purpose of this is to recognise Aboriginal and Torres Strait Islander peoples as the first peoples of Australia. The second bit of the text declares that there will be an advisory body called the Aboriginal and Torres Strait Islander Voice. The next bit says that the function of the Voice, or the job of the Voice, is to give advice or make representations to the Parliament and to the government. That's it. It just gives advice. It has no power to make decisions or veto decisions or to delay government decision-making or to administer programs. Its one and only job is to give advice. And then the final part of the text says it's entirely up to Parliament to decide all of the details about how the Voice will operate, which means that over time, Parliament can make the Voice bigger or smaller. Parliament will decide how it runs its operations. Parliament will decide how members of the Voice are chosen, and all of those things can be changed over time, just like all of the other structures and institutions that Parliament has set up. So the text is very simple, but it's really important because by declaring in the Constitution that there must be an advisory body, that means that, as Dani said just a moment ago, that it can't be taken away by Parliament. Parliament can change it, Parliament can make it bigger or smaller, however Parliament sees fit, but there must always be an advisory body for Aboriginal and Torres Strait Islander peoples if this referendum passes. And that's all we're being asked to vote on in this referendum in the middle of October. We're not being asked to decide other questions. It's quite a modest proposal, but the intention, of course, is that hopefully it has very positive effects going forward. So a lot of debate that we may see in the media and on social media in particular are talking about things that aren't actually the subject of this referendum. It's simply about, do we want to put in the Constitution language, new words that say there must be an advisory body for Aboriginal and Torres Strait Islander peoples? And it's nothing more complicated than that. And so, I would encourage people that when they are, just thinking about this issue and asking questions about this issue, and it's really important for all Australians to be asking questions about this issue, because the Constitution gives ordinary Australians, ordinary members of the public, power to change the Constitution. The framers of our Constitution insisted that it's ordinary people who have the power to change the Constitution, not politicians, but ordinary people. So every Australian has a responsibility and a duty to think about these issues and to ask questions. Asking questions is a really good thing. And when asking questions and discussing the issue with family and friends and workmates and so on, making sure that we know exactly what we're talking about. So the text of the proposed amendment is on the website of the Australian Electoral Commission. That's the best place to go for the clean, plain information about what it is we're actually doing in this referendum.
Thanks, Luke. I'll get you to stop. Oh, that's great. Thanks. I mean, one of the things that's come up in reference to what you've just spoken about, Luke, is people are saying, well, I don't understand what that voice advisory body will look like. And that's been something that's been sort of raised as a challenge. And the answer that we've talked about a number of times is that there's advisory bodies look like all sorts of different things. They could have 3 people or they could have 33 people on them. But there is actually a whole lot of work that was done on this by Professor Langton and Professor Karma earlier, actually under the request of the previous government. So there's a big report which we talk about as the voice design principles, which anyone can Google. And you can get the very, very long extended version of that or just a short version of that. And it gives us a model of what the voice might look like, but it's still going to be left to the Parliament, probably, this current.
And so this is important. All of the detail, the so-called detail that we keep hearing about, the answer to all of those questions is Parliament will decide. And what the voice if this passes, what the voice looks like when it first gets set up and what it looks like in 20 years or 50 years will be different, necessarily so. The same way that the number of government departments and what they each do has changed over time, in the same way that the number of federal courts that we have and what each court is responsible for doing has changed over time. In the same way that government policies and Centrelink payments have changed over time, Parliament makes those decisions and decides all the details, which means ultimately that ordinary members of the public get to influence those decisions because we vote in and out governments and parliaments, as we see fit. So if we don't like the way a particular government has set up the advisory body, we can vote them out and vote in a new government. But all the constitutional amendment is saying is there must be an Aboriginal advisory body, and now over to you, Parliament, to set it up and set out all of the details.
Thanks, Luke. Dani, I want to come back to you with something that's sort of very obvious, but some people still have concerns about it and are looking for some answers about this. I mean, of course, we understand that Australia has a very diverse and multifaceted First Nations population, and there's different communities all over Australia. To what extent do we think the Voice advisory body will ensure representation and inclusivity for all Indigenous communities from way up north in the Torres Strait to, far west or whatever, and we've got remote communities and regional communities. How do you think we're going to be able to accommodate the vast sort of diversity? And the question that sort of flows from that is, how do you deal with dissenting voices and we never expect unanimity from everyone in any real context, but how would the Voice have a structure that would accommodate the diversity in the opinions and advice?
Yeah, thanks for that question, Mel. It's a great question. My first point to make is to say that firstly, the voice or voices will be intended to, and this won't be decided, as Luke was just sort of speaking to before, it won't be decided until after a successful referendum is had, but they're intended to speak to one another as well as the executive and the parliament when trying to come up with law reform options based on differing grassroots community needs and interests. Now, even if some Indigenous community members aren't sold about the voice, but still want, change for the better in their community, they'll always have this additional means to feed their sentiment and message through to institutions where it actually counts, to Parliament and the executive, so that change can actually happen. So that's a good thing. But let me sort of break it down a bit more. So back in 2019, as you've just sort of highlighted before, Mel, when Scott Morrison was our Prime Minister and Ken Wyatt was our Minister for Indigenous Australians, Wyatt led a co-design process to table some potential viable options for how voice advisory bodies could look. So there was an interim report and a final report that set out the options. And for those of you that are concerned about the details, that's where they are. And mind you, that was under the LNP leadership. So hopefully the conspiracy theory out there that Labor and the Uluru Dialogues are hiding all the details of the voice is now somewhat settled. But I actually read through the over 300-page reports, and I've done webinars that break down the details that have been published by the LNP government at the time. And those webinars exist on the ulurustatement.org website. So I'd say go and check those out. But getting back to the point, so the co-design process basically mapped out that there would be a national voice enshrined in the Constitution, which is protected, and then there would be state and territory regional voices. Now, each of those voices have a two-way interaction ability, so they can listen to and speak to one another to come up with the best ideas for reform options that benefit Indigenous people. And the same principle applies to how they speak to the executive and the parliament. They can listen to and they can proactively make representations, advise parliament and the executive. So finally, the lines of communication would be formally established and clear. Now, where it gets even more interesting is that the co-design process thought about differing intersectional experiences that Indigenous people face with discrimination. And it came up with options for different subgroups of Indigenous committees to exist, which would give advice to the different levels of voice bodies. So there would be, for example, an elders, traditional owners group, there could be a youth group, there could be a disability group, and so on and so forth. Also, it's intended that membership is going to be gender balanced. So back to the roots of traditional Indigenous decision-making that treats men and women as equals and no white patriarchy. But finally, on this point, the Voices members will be either elected or selected from us, Indigenous people ourselves, so that we get to decide who we want and trust to speak about us and our affairs on our behalf. And that never happens for us at Australian elections because we're less than 3% of the Australian population. Now, while we differ, and we will all differ in views, and maybe some of us might need some more time than others to come around to this idea of the voice and to trust government, and that's totally okay, but this voice will give us a forum to talk through those differences with one another. Some people who participated in the Uluru Dialogue spoke about the idea of Indigenous people having to do treaty with ourselves before Australian governments, so from tribe to tribe. Now, what they were acknowledging when they spoke of that idea was how divided some of our communities and families have been since the establishment of the native title system. It gave us another form of recognised title to our own lands, but the way in which the system works also tore a lot of Indigenous communities and families apart. And there's a tremendous amount of healing to be done with that and coming together. And this is what voice forums can also do for us as a people. It can provide all of us with a safe forum of diverse views and identities, a yarning circle, if you will, to learn from one another and come back together again as a collective peoples in our plight for justice. So while some of us might not agree on the Voices establishment, but I do note that over 80% of us mob do agree, I think I could say with all certainty that we all agree that we deserve justice and that we want better conditions for our old people, we want better conditions for our youth, for ourselves, and for our sacred sites. We all don't want to just practice culture within the confines of the settler state either. We want to, you know, look abroad to places like New Zealand, and we want to get to a place in our country like where the Maori are at in New Zealand, you know, with how their culture is genuinely celebrated and respected in their state. So we want a similar kind of celebration for us and our culture. And I think many non-Indigenous people want that too. So those types of things we can agree on. We just differ from time to time on our ideas of pathways to get there. But we're all coming from a good place with good intentions to protect our culture, protect our old people, our babies, our youth, and most importantly, our land. So I'd say, you know, maybe the voices, once they're established, you know, they can be a way in which we can start sharing our knowledge, our experiences, and intersectional and geographical differences more with one another, and get to a place in time where we make decisions that reflect all the different identities and experiences of us as a peoples in institutions where it actually matters the most, where law and policy making processes occur through the executive and the parliament. So I think that's how voices will represent Indigenous people who differ in political opinion, identities, and of course the wants and needs across the country of us mob with when it comes to law reform.
Thanks, Dani. That you've really fleshed it out and filled in a lot for us in your answer there. I'm going to ask AJ a sort of related question, I guess, another perspective or lens on the same issue, and that is this issue of transparency and accountability and effective operation are so important in any democratic institution, and particularly people are concerned when you're creating a new institution, or they're particularly concerned with this institution about those issues. And how do we know Parliament will ensure that the voice has transparency and is efficient and operates appropriately and has appropriate decision-making processes? And I guess also people have raised, you know, how do we know it's not going to jam up government and become sort of an obstructive process? Do you have any reflections that you could share with us on that?
Yeah, I think, Melissa, Dani's just answered the most important part of that question, which is how will the voice be transparent and held accountable? Clearly, from everything that's gone into the development of this proposal and very clearly laid out in the results of the voice co-design process that Dani and Luke have already referenced. And like Luke said, you can go to voice.gov.au, find the result of that process, and it's a very clear report and it's a very clear proposal for how this will work. And transparency and accountability is a top principle written in there. And the key thing is that it will be bottom up, that it's very clear that although the Commonwealth Constitution is creating and will require that there is the national voice because it is the national constitution, that the consensus, and it's a consensus right across the board. I mean, local and regional voices is something that's supported right across the board, right across the political spectrum. So that's locked in, and it's a bottom-up structure so that people will come to be members of the national voice by virtue of being selected and delegated and sent from the local and regional voices to represent the communities in the way that Dani's described. There's total consensus around that proposal, and I think we can rest assured 100% that that's where the Parliament will pick up, and that's what it will do. The other thing to remember is that this will be a Commonwealth government statutory authority that is created under federal law, and it will be subject to all the same accountability and integrity requirements and mechanisms of any other Commonwealth statutory authority. And you can rest assured that Parliament will be doing that as well. And, you know, we've recently got a new National Anti-Corruption Commission, for example. You can rest assured that all of those frameworks will apply to this body. I don't think there's any doubt about any of that. And the other thing that is important, I think, because there's been a couple of questions about this, is that, you know, will it suddenly somehow be able to be given powers by the Parliament that are far-reaching beyond the contemplation of what what is in the text of the constitutional change? And the answer is no. So in the third part of the amendment, where it talks about the Parliament being able to give the voice, define the Parliament's responsibility is to define the particular powers, functions, etc. of the voice. That's all subject to the primary job, the primary function of the voice, as Luke described it. The way that the Constitution works, the way that the High Court interprets and applies the Constitution, we know this from 120 years of experience, is to read the Constitution as a whole. So the Parliament can't give the voice any powers, any function, fundamental function that goes beyond or is inconsistent with its constitutional function of making representations on matters relating to Aboriginal and Torres Strait Islander people. The scope of that, what that means, people can talk about. I think that's a fine scope. But it can't go beyond that scope. It can't suddenly turn the voice into something that goes beyond making representations. That's its defined constitutional function. But I guess I wanted to wrap up by saying two things. One is that I think we have to recognise the powerful change that this will make for the good, for the transparency and accountability of government, not the voice, but the transparency and accountability of government right across the board. If people are worried about efficiency in Aboriginal affairs, in making sure that the bureaucracy actually fulfills its purpose, this won't set up the bureaucracy. This will set up the mechanism for making sure that the bureaucracy, that the programs, that the spending on Indigenous programs are actually devoted and delivering against the objectives. It'll actually provide transparency and accountability to the way that millions, billions of dollars is rolled out, and in a way that does not occur. And I mean, I can say, as a Transparency International board member, that's the reason why we as a civil society organisation concerned about corruption and accountability, along with countless other civil society organisations, support the proposal, because it will bring transparency and accountability to billions and billions of dollars of government spending, which is currently not there, and do that by making the core stakeholders involved the ones who can actually monitor and tell us if this spending is achieving its goals or not, in a way that currently basically doesn't occur. And when we know that that's a big cause of the problem with these billions of dollars of spending. And I could go on about this in detail, why as a public policy person who's worked across government for 30 years, including looking into at times the way that previous bodies like ATSIC have worked, the strength will be in the transparency and accountability that the voice, especially the local and regional voices, but you have to have a national voice because we're talking about national policy, that will provide to the way that decisions are made and programs roll out, particularly those which is the bulk, where the bulk of money is spent from at the moment at the federal government level. So it doesn't actually make any sense to have local and regional voices without having a national voice, if we want to have an impact on all of this. But finally, and again, I just want to address a couple of the really good questions that people are asking here. Is the question about, well, why provide this transparency and accountability for Aboriginal and Torres Strait Islander programs if we're not providing it for other groups in the community? And I think that's a really good question. A few people have said, well, why don't migrants or members of other groups in the community get a constitutionally enshrined voice? And I think that it's really important to recognise that this is about, first and foremost, about recognising our First Peoples in the Constitution, because migrants and other groups that have come to Australia since the formation of the Commonwealth Constitution, the Commonwealth of Australia in 1901, or even since colonisation, apart from quite a few convicts originally, people have come here voluntarily to join a democratic society called the Commonwealth of Australia since 1901. So they've joined that political fabric. Indigenous people were never asked to join that fabric. They were here first and they had it imposed upon them. We need to heal that gap. We need to provide the rightful place of Indigenous people in the Constitution, and in a way that is not just symbolic, but which actually addresses the primary problem, which is that this Commonwealth of ours gets to make a lot of laws and a lot of decisions about First Nations people, despite them never being asked whether they wanted this colonial system of government imposed upon them. And the consequences of that are the ones that we're dealing with right through until today. So we should be proud about making the change to update our constitution to be part of this reconciliation journey. And we should want this change in order to actually address these really big policy problems that relate to Aboriginal and Torres Strait Islander people. And I would have thought that that migrants who've come to Australia to join the democratic system after that should see in this a step towards the type of institution that, whether it's in the Constitution or not, a commitment to involving stakeholders in their decision making. This sets a precedent for a new way of doing it. I don't think it excludes other people at all. If anything, I would hope that it's a historical development that says, hey, we can actually do this for the community in general better than we've done it in policy making up until now. But it's appropriate that this be for our First Peoples because they are our First Peoples and they were never asked if they wanted to join this system.
Thank you, AJ. You've raised something that takes me to the next point that I wanted to discuss with Luke, and that is this question of what's out there in terms of information and looking to find accurate information. And what we've found, Luke, is that we're having people say there's either not enough information or there's too much information, and people are getting their sources of, sort of slogans or comments from people that are coming off social media platforms or what someone else has said to them. And there's a lot of, I think, disinformation, confusion, and sort of unsubstantiated assertions about what will happen and what could happen, both about the referendum itself, with confusion of people saying, oh, there's multiple questions or there's multiple ways of fulfilling a referendum, and the voice structure itself. And what's perplexing us and what we're dealing with is the fact that people aren't actually obliged to write factually truthful things in this political discourse. And even in this question, and I saw there was a question in the Q&A about the yes pamphlet and the no pamphlet, the obligation for them to be fact checked so that they could put in a public electoral commission document any sort of stuff. So how do people work out what's accurate or not, and how come there's no truth in advertising in this political context?
Yeah, so it's a really tricky situation for people, particularly those who are not lawyers. So it's fine for you and me, Melissa. We're academic lawyers. We're across all of this. We're experts. But for ordinary members of the public who are not lawyers, it's really hard when you're hearing, quite contradictory information. So I think most Australians are familiar with the idea that we have deceptive and misleading advertising laws that apply in the commercial space. Businesses and companies can't try and trick you in their advertising. They can be, very creative and try to persuade you in all sorts of ways, but they can't lie. But in the political sphere, we're talking, federal elections and we're talking referendums, it's perfectly legal to tell an outright, deliberate lie. And the reason for that is because there's no law that says that you can't. And so we have a phenomenon where in the federal arena, you're allowed to tell political lies. You can make stuff up. You can deliberately try and trick and mislead people. They do things slightly differently in South Australian state elections and in ACT territory elections very recently. But since the 1980s, South Australia has what people generally refer to as truth in political advertising laws that effectively work the same way as deceptive and misleading commercial advertising laws, which says it's unlawful in South Australian state elections to make a purported statement of fact about politics that is materially false. So, it's not about blocking opinions or censoring differing opinions. People with all sorts of different contradictory opinions can still freely express those. And of course, I'm sure we all realize that, since the 1980s, South Australia is and remains a vibrant democracy. But it prevents people telling outright lies, making things up, deliberately tricking people. So a couple of examples that went to court that explain this idea. There was a case about a flyer that was about some political advertising, where it was said that the then government had said that public schools with fewer than 300 students would all be closed. That was held to breach South Australia's truth and political advertising laws because the government of the day had never actually said that. That was completely made up. Another case that shows the opposite outcome, a politician got a little bit upset because someone was handing out flyers calling him soft on crime, and this politician wanted to have a reputation as being tough on crime. And the court said, well, we're not getting into whether that's true or not. That's merely an opinion, and opinions are free. You can express whatever differing opinion you like. So you can't make up facts, but you can express all sorts of differing opinions. Whereas in federal elections and in this federal referendum, you can make up facts. You can just outright lie. Now, federal Parliament's Joint Standing Committee on Electoral Matters looked at this question about, should we have federal truth in political advertising laws? And they said, for the purpose of this referendum, no, we shouldn't. It's too late. There's not enough time to do it properly. But going forward for future federal elections and future referendums, we should have South Australian style truth in political advertising laws as one mechanism to sort of make a dent in this more modern phenomenon of mis and disinformation. Now, there's one exception to that. Whilst you're allowed to make up things and tell outright lies in federal politics and federal referendums at the moment, you're not allowed to mislead people about how to fill in the ballot paper. So that's numbering the boxes in the federal elections or writing yes or no on the ballot paper for the referendum. So if someone puts out an ad, for example, or it says, you should tick the box or cross the box, and we've heard a little bit of that in recent weeks, that's misleading people as to how to fill in the referendum ballot paper, because the manner of filling in the ballot paper is writing the word yes or no, depending on how it is you wish to vote. So that you can't trick people or mislead people about how to fill in the ballot paper. The law puts a stop to that. But you can trick people and mislead people and lie to people about the Voice proposal, about federal politics more generally, if you want. And that makes it really tricky for ordinary people, because they don't know that there's a base level of truthfulness to what we see in advertising in respect of politics. Whereas in the commercial space, people know that despite all of the clever marketing and persuasion efforts going on, there's a base level of truth. We all know that companies, businesses are not allowed to lie to us about their products and services. Whereas in politics and the referendum, we know that people are in fact allowed to lie to us. And then that puts a really huge burden on ordinary Australians to do their own fact checking, to double check everything that they're told or read or see. And, that's not really realistic to say, to everyday people that, by the way, you can't trust anything you read or see, which means that all the ordinary sort of advice that people give around media literacy, checking sources, who is saying this to you? What is their angle? How would they know? All of those kinds of questions people need to keep in their head whenever they're reading or seeing things about the Voice referendum, because, is what you're reading accurate? Are the people pushing it? Do they have an angle? Are they qualified? Do they know what they're talking about? Maybe they do, maybe they don't, but it's a really tricky situation for people.
And I think that to add another layer to that, we normally instinctively trust the Australian Electoral Commission to be a valid source of truth. And yet what's gone into both the yes and the no campaign document, the pamphlet as it's called, the thing that we're all going to get in our letterbox,
and then we have the
fact checked by the AEC or someone else. Now, there are other sources where people have gone ahead and not in the AEC, but academics have gone and fact checked arguments, but it still requires people to go looking, right?
And there's an important reason for that. So the law says that the politicians, the members of the House of Representatives and Senators who voted yes for the referendum, they get to put together a 2,000-word essay arguing why people should vote yes, and the members of the House of Representatives and Senators who voted no, they get to put together a 2,000-word essay arguing why people should vote no, and the AEC has the job of delivering that to all Australian households. And that's what the law says. The law says that the politicians on each side of the debate get to write their little persuasive essays, and the AEC must deliver that to every household. And so the law does not allow the AEC to fact check that. The AEC has no power to fact check that. So if they started going around fact checking the booklet, the AEC would not be doing its job properly. It would be acting contrary to law. And the law equally doesn't require those politicians to tell the truth. The law allows those politicians on both sides equally to make stuff up if they want. And so the booklet that we got, which is 4,000 words plus the AEC's top and tailing of it. I mean, firstly, I don't know that too many people are going to read 2,000 words written by a bunch of politicians, 4,000 words written by a bunch of politicians, but it is perfectly legal for that to contain all sorts of lies and mistruths and, you know, misleading material. But it's not the AEC's job to fact check that. They're not allowed to fact check that. So, you know, there has been some media commentary, well, you know, or on social media where people say, well, you know, why on earth is the AEC sending things out that they know might be false? Well, because the law says they have to do that. And the AEC, as the independent election authority, will obey the law to the letter. And the AEC has a very long and distinguished record of conducting very high integrity elections. Now, the AEC does have a misinformation register on their website, and that's essentially fact-checking claims made about the referendum process. And so that's an important limitation. That claims about the process, so how the vote is conducted, how the AEC organises the electoral rolls and voting day, all of those kinds of things, where there has been, you know, misleading or false information, the AEC has put together a register that outlines the false claim, and then where the AEC actually explains what the real situation is. And so that's a really important resource that people can look up on the AEC's website, but that's only about the referendum process. It's not about the voice proposal. So where there might be misleading claims about what we're voting on, or what the voice might do or might not do, or might look like or might not look like, the AEC can't get into that, because the AEC, the Electoral Commission, has to be strictly neutral. It can't be seen to be taking sides, and it has no legal power to engage in fact-checking on those substantive political issues. It can only talk about the process of how the voting takes place.
There were a couple of fact-checking media sites that you spoke of with me previously, and I'm going to put you on the spot and say, can you remember which ones that you were recommending that people have a look at?
So a whole bunch of media outlets have fact-checking services that are looking at referendum issues, but also looking at fact-checking about all sorts of other things in public life, politics, business, etc. So there's RMIT fact-check, there's AFP fact-check, there's AAP fact-check, there's ad hoc fact-check articles, you know, in newspapers like The Age and Sydney Morning Herald or The Guardian, or on ABC News Online. It's a whole bunch of them. Now, and what those articles, they all tend to adopt the same sort of approach. They look at a claim that, you know, somebody prominent has made, or that's sort of taken off on social media and gone viral, and then they go around and talk to a bunch of experts and other people to check, you know, whether that is whatever the claim is true or false, or more to the information, more to the story than what the quote might suggest. So there's a whole bunch of stuff out there in sort of mainstream media outlets, and so you know, it's important for people to sort of read up on those kinds of things as we approach, you know, voting day in 5 or 6 weeks' time. You know, the more we read and think about and reflect on whether we should vote yes or no, the better, and make sure that we're reading material from more reliable sources who quote from more reliable or knowledgeable people.
Thanks, Luke.
My pleasure.
Kate, we have this situation before us where the various voices that are addressing, sorry, the various views that are addressing the voice proposal in the referendum are sort of both saying it does too much, and then also saying it does too little, and that causes quite a lot of confusion and sort of, it's perplexing for people how it could be doing so much and yet be doing too little at the same time. But I wondered how you would see the potential, you know, enduring impact of the Voice to Parliament, both on Indigenous rights, but also for Australian society and culture in general, and the broader relationship that we have to come to grips with, which is the relationship between Indigenous and non-Indigenous polities or communities in Australia.
Thanks, Melissa. For me, I think one of the key things that's going to happen is we're going to flip it. It provides us the opportunity to flip Australia's consciousness about Aboriginal and Torres Strait Islander peoples from one of race to one of their status as First Nations in this country. So there's been a lot of talk in this referendum about how the proposal is racially divisive or introduces race into the Constitution as though it was some sort of novel thing. I think that this really misunderstands the foundation of our Constitution, which is really race. We already have in the Constitution what's known as the race power. And that's one of the powers given to Parliament to make laws with respect to the people of any race. And as I mentioned earlier, this law is only used, has only ever been used to make laws in relation to Aboriginal and Torres Strait Islander people. No other racial group in society has ever had a law made about them under this power. And what this signifies, I mean, the people who framed the Constitution, the men who framed the Constitution, were radically concerned with being overrun by racialized hordes from overseas, didn't really think about Aboriginal and Torres Strait Islander people all that much. But what's happened is we have this constitutional obsession with the idea of race to the exclusion of thinking about Aboriginal and Torres Strait Islander people as peoples who are Indigenous to these lands. Now, what I think is such potential from this referendum change is for us to stop thinking about race in this country and start thinking about indigeneity. Start thinking about those fundamental connections with these lands and waters spanning back tens of thousands of years. We know that as First Nations people, Aboriginal and Torres Strait Islander people hold recognised status at international law, and they hold recognised status within Australia as well. But we're legally and socially confused about this, and we keep calling it race. It's not about race. The rights found by the Mabo case and enshrined in the Native Title Act all relate to this question of indigeneity, traditional laws and customs that predate settlement in Australia. So I think that what the real opportunity for us in this proposed change is allowing us to understand First Nations peoples not as separate races, but as culturally distinct peoples with tens of thousands of years of connection to these lands and waters. I think in this respect, Australia's a long way behind some of its fellow colonial settler nations, as Dani mentioned earlier, like New Zealand or Canada. So the road has certainly been a long one for Indigenous peoples in those countries, and certainly challenges remain. But the advantage that they have in those countries is that their Indigenous peoples have a place within the national consciousness. And that has occurred through treaties, through other forms of recognition that are enshrined in law. So this really close relationship with social understandings of Indigenous peoples and the legal framing around Indigenous peoples. So in Australia, we don't have any story like that to tell about Aboriginal and Torres Strait Islander peoples. We're we're cemented in this 19th century view of race instead of thinking forward and understanding the true status of Aboriginal and Torres Strait Islander people. So we do feel proud of the 1967 referendum. We feel proud generally of the Mabo decision. And these were two legal milestones in our nation. But The Voice provides a way for Australians to think quite differently about First Nations people, become aware of Aboriginal and Torres Strait Islander people as people of authority, people who hold positions of authority within our national institutions. And we'll see a space within our national institutions for Aboriginal and Torres Strait Islander people to hold government and parliament to account according to this status as the first peoples of these lands and waters.
Many thanks, Kate. You've covered quite a lot there, and we have indeed sort of covered a wide range of issues in this session. Now, I'm very conscious that we're coming up against the clock, and I can see that there's many questions that are in the Q&A. But now that I've had a chance to have a look, and I think we've actually been able to weave in quite a lot of the things that people have asked us have come in our discussion as we've gone along. So I'm pretty sure we're not going to get a chance to interrogate those questions one by one. But I am very grateful for people popping those questions in as we've gone along, because it's given us a chance to to address in our comments and in our questions and my questions to our panel some of the key questions that are in there. So I am very grateful for those questions. I wonder if I can push my panel to each give a closing comment and keep that closing comment really, really brief. So I'll start with Dani, but if there's just a sentence or two that you wanted to say in closing, would you like to share that with us?
Yeah, thanks, Mel. My closing comment would be, well, firstly, I think this popped up in discussion before, just because the voice might wield a sense of power, it doesn't mean that we're trying to take anyone else's, land, backyard away from them, as some sort of no campaigners would misrepresent. The goal is really simple. It's about unity. That's all that this proposal is about. So I would encourage you all to go to the lawyersforyes.com website and the ullaruestatement.org website. And I would encourage everyone to do some reading, watch the webinars and engage. And then I'd say, have a think about the legacy that you want to leave. What do you want to represent? What side of justice do you want to stand on? Writing yes, in my opinion, on the ballot places you on the right side of justice, because you open your heart, your mind, and your entire world up to the world's most long-standing ancient Indigenous culture. In doing so, you offer justice, respect, and humanity to Aboriginal and Torres Strait Islander people. And in return, you'll feel so much more in love with this country than you ever have had and felt before, because you open the door to learning about the wealth of history and tradition that this country has of Aboriginal and Torres Strait Islander culture, which has been kept secret behind closed doors by past deplorable government decision-making that's divided us all. So I think that we can do better in 2023, and I encourage you all to read, engage, learn, have discussions amongst yourselves, and hopefully vote yes.
Thanks, Dani. AJ, do you want to give us a closing comment?
I'd just like to address the question that, and I think we better answer all the questions that people have asked directly, even if we don't have time to answer them now. I think we will get back to everybody on the very good questions. But there was one question there about what's the likelihood of having another go at recognising First Australians in the Constitution if we fail this time. And I think it's really important for people to recognise that it's not a question of, recognition or the voice. The voice is a form of doing that recognition, and that there's been decades of thought and research and consultation to identify what we really need, which is a form of recognition, which is not just symbolic, which doesn't just simply say, thanks to Aboriginal people and Torres Strait Islander people for surviving for 65,000 years, and we love your artwork. It's got to be something that will substantively recognise the place of First Peoples as First Peoples, and giving them a constitutionally enshrined voice will not only do that, but it will actually make a substantive difference. And other proposals that have been there have been very symbolic, and we know that they rightly don't enjoy the support of Indigenous people or the vast majority of Indigenous people, and nor should those purely symbolic forms of recognition enjoy the support of the rest of Australians. We need something more substantive than that. And I guess that's why I'm quite comfortable that it would be ideal if we went into this with a higher level of consensus and more time perhaps to thrash through exactly why this is a good proposal in light of all of that history, the decades that have gone that we're, as constitutional experts, we're familiar with, but which most citizens, rightly aren't aware of. It would be ideal if we had more time, but I'm quite happy to vote based on what I know and the information that is out there, that this is a form of recognition that will make a substantive difference and take us on a continuing path of reconciliation. We can continue to talk about treaty. We will need to continue to talk about truth. We can continue the conversation, but this is a huge step on that road, a huge positive step on that road. So that's why, despite the fact that unfortunately it has become quite a divisive debate, I keep coming back to those fundamentals and saying, I'm really comfortable to say, after a long period of deliberation already, this is the time. The time is now. Let's vote yes to this.
Thanks, AJ. And I'll take a very brief comment in closing from Luke and then from Kate.
Thanks, Melissa. I think we need to recognise that this is a very Australian proposal. It respects the fundamental principles of our existing constitutional system. It's just an advisory body that gives advice to Parliament. Parliament remains supreme, and that means we as ordinary voters remain supreme. And the second key Australian aspect about it is premised on a fair go. Ordinary Australians have an opportunity in the middle of October to exercise their constitutional power to vote yes, to give a fair go to Aboriginal people, to give them the advisory body that they have respectfully requested. And the outcome of that does not take away from anybody else, but it means that by voting yes, ordinary Australians can do one very tiny thing to make the country just that little bit better.
Thanks, Luke, and over to you, Kate.
This is a once-in-a-lifetime opportunity for us collectively to think aspirationally about resetting the relationship between the Australian state and Aboriginal and Torres Strait Islander people. And it offers the chance for us to think structurally instead of continuing to try to patch up individual problems. Thank you.
Thank you, Kate. And thank you all for joining our webinar today on talking about the voice, a conversation without the noise. We have raised a number of different issues, and no doubt you'll want to learn more about these issues. There are great resources via the Castan Centre's own resource page, but there's many other excellent resources out there, including the Voice Legal Literacy Project on legal education, and the Australian Human Rights Commission pages, and some of the other resources that we've popped into the chat already. So I've just mentioned a few, but there's more. But I do want to thank our supporting organisations, the Australian Association of Constitutional Law, Griffith Law, and the University of Queensland. I want to offer a particular thanks to Gina and Scott at the Castan Centre and Temi and the team at Law Events who have done all the back of house work here today, and our colleagues at the supporting institutions who are also working back of house to make this all come together. I want to thank our terrific speakers, AJ, Dani, Kate, Luke. You've done a terrific job of explaining some diverse and complex issues really clearly for the audience. And I want to really thank the audience for taking the time for joining us and thinking thoughtfully about the issues, to learn more about the referendum and its processes and the proposal for the Voice to Parliament. And as we said before, it is a simple but profound moment, and I'm glad that you're taking such an active part in it. So we will close off now and the webinar will finish, but I hope your inquiries and your conversations continue from here on in. Thank you all very much.